welcome again. Having diverted some of our attention towards the unlawful activities of local councils and making a couple of presentations to community groups about forthcoming information regarding the Local Government Funding Authority, LGFA, it's important to shine a light on this option being pursued by this particular group of criminals. Not that the LGFA, a limited liability corporation, is itself criminal apart from its use of usury, expressly forbidden under Magna Carta 1215 Clause 11, which places it in that category along with all the banks, etc. But the local councils definitely are criminal in nature. Why is this? The first point to remember is that there is no provision under the constitution we live under, which is Magna Carta 1215, not the defunct fraudulent Australian constitution, for anyone to extract or extort taxes from anyone else. All Crown subjects are equal under the law, and even the monarch has no authority to order anyone to do anything which may be against their conscience or which causes harm to anyone, including themselves. That is the first principle, and everything else is subordinate to that principle. If people wish to have projects or programs funded to suit some personal agenda, even if they claim that it is for the benefit of certain deprived individuals or society in general, that still doesn't give anyone, and certainly not any group, the right to arbitrarily impose that program or the funding for it onto any other person. As soon as that principle is breached, that's the end of equal rights or equality under the law. By all means, people are free to propose such schemes or projects, but it must remain the province of each individual to either participate voluntarily or not. Nowhere is this principle more eloquently expressed than in the case of the conscientious objector to conscription or participation in warfare. There can be no more pressing argument for the supremacy of the group over the individual than the issue of the nation being at war, even an existential war. In the past, people were executed for refusing to be conscripted or to fight, and it was not until the 20th century that the principle of conscientious objection was finally accorded validity. That is how slowly the concept of individual freedom and the right to choose how to dispose of one's life has been to enter the collective conscience of the people. And that is only in some parts of the world. In many places, the penalty for refusal is still death or imprisonment for the duration of the conflict. Any constitution which doesn't recognise and uphold this basic principle is invalid because it immediately negates the concept of equality under the law. Thus, even without the invocation of Article 61, the 1901 Australian Constitution was and is invalid. We can construct complex arguments citing provisions of that defunct document to demonstrate the invalidity of local councils and purported government authority, but it is an exercise in futility because the initial rationale behind that fake constitution is null and void from a purely moral viewpoint. It is fortunate that Article 61 has provided lawful excuse to dissent from the corrupt systems now in place, because that tends to minimise the level of violent reprisals to which we may be subjected. Only when enough people grasp and adhere to this principle is there going to be any worthwhile improvement in the lot of humanity in general. That is why local councils, along with any other form of governance which asserts the right of some to override the rights of others, are criminal organisations, no matter what kind of fancy language is employed to justify their existence or activities. If they were content to exist on the basis of a voluntary participation, like hundreds of thousands of other registered corporations, which do not attempt to coerce people to deal with them, there is no doubt that very many folk would happily go along. What about roads, someone says? Why should people who refuse to contribute get to use roads which have been improved by the pay of others? There's no reason why those who don't pay voluntarily for such things should receive such benefits. Those who decline to pay may have to pay a toll to use such facilities and will calculate according to how much use they get from those roads whether it is best for them to join in the scheme or not. They may make the same decision concerning whether to pay the council to remove their rubbish or avail themselves of an alternative service. There in reality aren't that many functions which local government provide which couldn't be done at least as efficiently by a legitimate private enterprise. Let's not lose sight of the fact that councils as they currently exist are just that, private enterprises misappropriating the machinery of state to seize a monopoly in their area of operation. The issues of grievances by one neighbour against another are not lawfully the province of private corporations set up to facilitate such resolutions by levying costs against people, with the residents unsure about the destination of the funds thus raised. Such issues are in fact the proper province of the courts, where someone who alleges that they have been harmed may bring a publicly funded action against an alleged offender, as stipulated in Article 40 of Magna Carta 1215. As well as determining by a jury trial, Article 39 of Magna Carta, whether the offence has actually occurred, the jury's responsibilities include establishing that any harm caused was intentional and committed with malice aforethought. Mens rea is the Latin term. The verdicts and court orders arising from such considerations would vary according to the jurors' exercise of their common sense and knowledge of the law, in which they could be assisted by a court convener. But aren't the courts already overcrowded and months or even years behind in their schedules? A breach of Article 40, we hear people say. That would not be so were the courts fulfilling their proper function instead of the false, perverted system we now have, where huge numbers of cases arise from the police abandoning their role as custodians of the peace and initiating billions of dollars worth of revenue-raising cases involving, for the most part, nothing that can reasonably be termed a crime, the sole purpose of which being to fund the corrupt legalese system and enrich those corporations busily prolonging their usurpation of the crown. The removal or absence of those cases would enable the court system as designated under Magna Carta 1215 to function much more smoothly. To return then to the question of unlawful local councils, the average Australian has little or no knowledge of how constitutional law overrides statute legislation and simply can't be bothered to take on board the information or act to compel obedience to constitutional law from parliamentary representatives. Even if we could get these people to understand that in Australia we live under the common law constitution of Magna Carta 1215, still most have apparently little motivation or courage to even advise those pretending to be Crown officials of the criminality of their actions. It's been a maxim of law since time immemorial that neither an entity nor an individual can grant or give to another that which they do not possess themselves. This is why there are laws against disposing or receiving stolen goods. It's precisely the same principle. This principle applies under Magna Carta as it does with any valid constitution. We are talking here of a universal principle of natural or moral law which applies no matter what legal system may be in place. Until most of the population accepts and adheres to such common law precepts, there is no possibility of resolving any of the ongoing conflicts in our society on a long-term basis. Without this acceptance, the best that can ever be achieved are short-term, range-of-the-moment policies, which will always eventually unravel into failure because they permit some people to exercise unrighteous dominion over others for personal benefit. Thus, continued acceptance of the unlawful presence of local government and councils by the population at large is bringing and will continue to bring unwarranted suffering on all Crown subjects. And it is impossible to argue cogently that this suffering is not thoroughly deserved. Both the principles and the law involved are plainly apparent, and there is no objective spiritual or moral difference between turning a blind eye to any form of evil, from petty crime up to and including murder and treason. All these are merely degrees of moral abdication of responsibility. Of course, the penalties the universe extracts from these various levels of depravity vary, but there is no escaping the universal rule that immorality results in loss of freedom. This occurs through individual slavery to personal vices, which are not in most cases crimes in themselves, through to outright slavery to individuals who are prepared to commit crimes without encountering lawful resistance. Now to the latest news on this local councils front. There exists in New Zealand and South Australia corporate entities called the LGFA, referred to earlier. In both cases, these are limited liability companies with the authority to lend to any local councils in their jurisdictions. And in effect, they are the primary source for councils which need more funding than would normally be forthcoming from their revenue sources, the major one of which is property rates. So here we have the unconstitutional local governments devoid of any lawful authority, openly charging direct taxation on the value of an individual's real estate property. It can be argued that people are not obliged to purchase a dwelling, but how most of the population would be housed if they all opted only to rent properties built by speculators is surely something of a moot point. Other states in Australia rely mainly on grants from various state and federal organs for occasional or specific project funding. Member of the New Zealand Loyal Party, Liz Gunn, has posted videos highlighting that the loans a local council may obtain from the NZLGFA are secured by the revenue-raising capability of the relevant councils. The situation is the same in South Australia, according to the web pages of these corporations. That may be fine as long as the current global financial system remains viable, but it raises a spectre of the long arms of bankers reaching into homeowners' pockets should there be a general malformation of that order. Corporations exist solely to provide returns for shareholders, and there's plenty of historical evidence that banks place their bottom lines above the interests or needs of homeowners if there is any perceived conflict between those two objectives. Given that it's a universal law that all frauds are eventually exposed, with all fiat currencies eventually succumbing to reality and devaluing to zero, resulting in the collapses of economic systems based on such frauds, homeowners should perhaps be paying far more attention to the lawfulness and long-term viability of these local councils. It's becoming clear that attention to the old maxims buyer beware and believe half of what you see and nothing of what you hear is increasingly vital, especially when dealing with criminals who are demonstrably untrustworthy, as are all levels of corporate governance, which is all that we currently endure in Australia and elsewhere in the British Commonwealth. It is imperative to not only learn the facts of this chicanery, but to act against it while we still may. In the long run, the soft option becomes the harder one. Thank you for watching.